All right, so welcome everybody to our Telehealth Facts Friday. And today we're going to cover some of the legal aspects of telemental health. And with us today we have Helen Oscislawski, and she's an attorney. Her firm is Oscislawski LLC. So you can find her on her website, which is oscislawski.com. Do I have that right, Helen?
Actually, drop the SKI, so just oscislaw.com. So it's
There
easy,
you go.
less typing.
Perfect. Yeah, and we will definitely put that in the chat. So there's a lot of legal questions about telehealth, and Helen's here to help us out. By the way, she was selected in 2020 as one of the super lawyers list for healthcare law in New Jersey, issued by Thomson Reuters. She's very well known for her work with the legal aspects of health information exchanges, HIPAA law, a lot of privacy laws, 42 CFR Part 2 for privacy and security law around healthcare information regarding substance abuse treatment. So she is definitely an expert in this field. And I also want to let you know that we recently held a fantastic summit, which was awesome. Thank you guys for showing up. And Helen provided an amazing session. So she got incredible feedback. People loved her. She answered their questions, and they put a lot of extra questions in chat, which she responded to in a document. So that was extremely helpful. We really appreciate that, Helen. And we're going to make that available as an online self-study course on our site. So you'll have that available to you within a week. So again, Fact Friday, right? So this is to get some really kind of key answers to the questions that a lot of clinicians have. And as we go through this, please respond through the comments, right? So below this video, type in the comments, ask questions, give feedback. We'd love to hear from you. So Helen, one of the big things, obviously, in the United States, since we have state licensure law, which is, has to do with the region of each state, which makes things really complicated, is if someone is seeing their client, so let's say a clinician is licensed in New York, and their client is normally in New York, but their client's temporarily visiting another state. Can that clinician legally continue to provide that service? I know it kind of varies across states, but how does that work?
Yeah, so it does vary across states. And first of all, thank you, Ray, and to your organization for having me on today. This is kind of fun. I've never done these, so I'll try to be as animated and as interesting as Ray. So there, the question has obviously come up. It's not a new question. There's been a number of collaborations across the United States that have attempted to help with this issue. But in short, across the board, first of all, there's no federal law that addresses this and gives you an answer to it. Unfortunately, we're left with a patchwork of going state by state. So depending on where you are in the United States and what 2 states or 3 states we're talking about, or whatever states, wherever your client may have gone on vacation or whatnot, will affect the answer. So if you're licensed, but to take your example, if they're licensed in New York and your client has gone down to Florida for whatever time, and you hold no license in Florida, you are not permitted essentially to provide clinical services or professional services to your client in Florida, generally speaking. There are a number of states, including Florida, that have temporary provisions where you could apply for a temporary license. These vary from state to state. Some of the processes are very quick. Some will give you a temporary license for a determined amount of time, but at the end of the day, you will have to determine whether or not and what are the criteria for you getting such a temporary license, and you will have to get some form of temporary license to provide telehealth services in that state. There could be states that don't allow it at all, or have such stringent criteria that you're not going to be able to meet them. So that's the key. Depending on whether you're a psychologist, a psychiatrist, or a clinical social worker, that in turn also will affect the answer. There's been, as I mentioned, collaboratives like the PsyPact, and some other efforts that have tried to get that process going a lot easier. So once you do get that temporary license, say for 30 days or whatever, you could then provide services to your patient, your client in that state. Remember that you have to follow that state's requirements with regard to telehealth. So now you have to be aware, not only do you have your temporary license, but you may not be able to do what you're customarily used to doing in your home licensure state. So you might need to do some homework in understanding what are the new criteria or different criteria with regard to consent to treat, without regard to documentation for telehealth, whatever, and whatnot. And the last thing I would mention is to make sure you check your insurance carrier, because if you're covered for malpractice in your home state, just make sure you're covered if you're providing those services outside your jurisdiction.
Yeah, and one kind of pushback on that is the interstate commerce law. So if it was actually brought to court, some attorneys say, well, hey, that would go against interstate commerce law, because this is a customer of mine that I'm providing services to. They just happen to be in another state for a period of time. And also, it's fairly common where physicians will still talk to their patients over the phone when their patients are in another state for continuity of care, and they'll still prescribe medication in that other state, right? So they'll have that medication waiting for them at a pharmacy in the other state where the patient is while they're on vacation. Right, so they get a phone call. Hey, I'm having these symptoms. Oh, yeah, I'll send in a prescription for you. So that's pretty common, right? So how does what do we do with that, or how do you see that in regards to this? Because you have state licensure law, but then you have practice and interstate commerce. And
yeah, I'm not really sure about the interstate commerce angle and what that's all about. I know my husband's a physician and he's prescribed in other states. Licenses, DEA licensors are controlled by federal law. And so if you happen to be a psychiatrist and you're able to issue your licensure and your prescription is governed by federal law. So if you prescribe opiums or whatever, there's a whole other body of law that can regulate that from a public safety perspective.
Uh-huh.
I'm not really sure about the interstate commerce with that angle. I've never looked at that angle. I just know from a regulatory and a public safety requirement and a public safety that state agencies have the right and authority to regulate the public safety of the people who are in their state. And so if you're caught doing that without a temporary or adequate license, maybe there's no immediate repercussions to you in the state that you're providing the customer or the client with temporary services, but you can get reported to your own home board, and then you can be subject to potential review and inquiry with regard to your own license. So,
yeah, that's very helpful. And, and going along with that, some clinicians, because of, having a specialty, so they might eat with just clients who struggle with eating disorders. It's really hard to find a clinician in your area who specializes in that. So they'll get licensed in multiple states to provide the really needed services that they provide. So they're regulated by these different licensing boards that they chose to get licensed by. So now when they're seeing a client that's in one particular state, right, they have to follow the laws, rules, and regs in that state under the appropriate license that they hold. But then they still have a license in all these other states that have different regulations. So like one example, there's one state at least that says, teletherapy cannot be provided through asynchronous means, say like secure messaging. But so if they're licensed in that state that says that, but they're providing services to a client who's in a state that doesn't have that restriction, how do they make those decisions when they have competing laws or age of consent or duty to warn or stuff like that?
I mean, you might be getting into conflict of laws and reconciliation of conflict of laws, but I think generally speaking that the policy behind those types of regulations are that a state has decided the parameters of what should be in place to protect the residents in their state. And so they have the primary authority and obligation to do that. So I think as a rule of thumb, that the state in which the patient is currently residing or in would be the controlling provision that you need to follow. So if if the state where they're in says you can't do that, then you can't do that even if your home state says you can, because the patient or the client is in the state where it says you can't do that. If that were to, for instance, get litigated or whatever, and you went to a conflict of laws analysis of state versus state, I'm fairly certain that the state in which the client had the minimum contacts or had the actual presence in would be the controlling provision for that particular episode if there was any harm or any issue that came out of it.
Mm-hmm. Yeah, and then it seems like if you were seeing a client, say, let's say, so like Louisiana, the counseling board there says like you can't provide teletherapy through asynchronous means. So let's say you have a client that is normally in Louisiana, you are providing services to them, but they're temporarily in another state that you do have authorization to practice. So I guess what I'm saying is if Louisiana says you can't provide teletherapy through asynchronous means, but that client that you normally see in Louisiana is visiting, say, Texas that does allow it, can you then provide it, or should you still also adhere to the stricter restriction of Louisiana?
I would say if the patient's in Texas, you're permitted to follow Texas law.
Okay, yeah.
That episode of care. I
like that clarity. Yeah, that helps a lot.
That would be my argument.
Yeah, hey, that's good, right? They're in
again, it's the state deciding, so the question is, I guess the legal question would be whether and this goes to, if it's just a visit and then you got the snowbirds who are spending 50-50, what state, I just feel like, generally speaking, it would be the state in which the patient is receiving the service, and the public health and the safety of that patient is determined by the laws of that state in which they are. So as a general matter. So can somebody make an argument if something went awry and that patient wanted to sue? And now we're getting into litigation issues, which is not generally my area of expertise. Any argument can be made, but you can see somebody making the argument and trying to say, hey, look, this is where my patient lives and you need to follow that. But I don't know how that would, and that probably would reconcile in different ways from state to state and how that's been interpreted or not, so a licensing perspective and who you have to follow, I just can't see if you're licensed in, for instance, New York again, the patient lives in Louisiana, you have a license in Louisiana, and they're temporarily in Texas. Is Louisiana going to enforce their standards against that patient when that patient is visiting in Texas? It just doesn't seem to me that would be the case. So it would seem to me that the jurisdiction in which the patient is during the actual episode of care would determine what is permissible and not permissible.
Yeah, and making these decisions, one of the big questions is, where does the service take place? So when providing telehealth services, where does it take place? At the location of the client or the clinician, or both, through wherever the radio frequency and flow of electrons flows, right? Because we're using technology. So some state licensing boards actually state where it takes place. Most of them that state one way or the other say it takes place at the location of the client, right? But some states say that it takes place at the location of the client and clinician. So it really kind of makes things confusing there. Is that come up for you?
Good.
Yeah.
What's that?
Has that come up for you ever?
No, it hasn't. Yeah. I mean, not on a practical level, but yeah.
Yeah. So like I can give you an example. So like North Carolina, their counseling board says that telemental health takes place at the location of the client and clinician. Really complicates things, because if the clinician, right, was in another state that they're not licensed, right, but the client is in a state that they're licensed, North Carolina licensing board, at least the way it's written, right, for the counseling board, really makes that difficult. So, a lot of clinicians in practices and organizations might have legal questions around providing telemental health. And, they're likely to have professional liability insurance that gives them some time for consultation with an attorney. But I wonder if they have to be careful as to what attorney they get assigned, and like how to find an appropriate attorney for telehealth questions, for setting up telehealth services in the first place, and then questions that come along. Any recommendations in terms of vetting out, attorneys for this kind of work?
mean, again, you'd probably want to start with the state in which you're practicing, or
Uh-huh.
what is the state of issue. You could, if you're been assigned an attorney, I guess I presume that the attorney's been vetted with some competence in the area that, given the fact that they've been assigned to you. If you're searching for one, generally attorneys in the healthcare area and arena have a fairly strong grasp of regulatory and licensing issues. And so I would say a healthcare attorney, regulatory attorney in the healthcare space would be of the expertise, or at least of the knowledge, to be able to provide or at least find the answers that you need.
Yeah, that's great. So in your state, right? So they know your state laws, and working in the healthcare field focused on healthcare law.
Right. I wouldn't necessarily say litigators, because although they obviously have their area of understanding, somebody who's more dealing with the regulatory, there's actually attorneys who deal, if you do have a board issue, and if you have reported to the board, there are actually attorneys who specialize in board representation in front of licensing boards. So, and you can see that from their bios. Go onto their website, do a little investigation. If you're really lost with a place to start, go to the State Bar Association, explain to them what you need, and usually they'll head you in the right direction.
Oh, okay. That's a great idea. So for your firm, right, Oscislawski, LLC, what are the really good fits for you in terms of clients? Right, you're barred with New Jersey
And
right?
Arizona.
And Arizona. Okay, yeah, excellent. Yeah, so what would be in terms of telehealth? Are the clients that are a fit for you? What would they be looking for?
I work predominantly with institutional clients, to be honest with you. So, the majority of my clients, so if you are a behavioral health or addiction service provider, and are in the behavioral health unit, or you're a practice who services a behavioral health unit, or you're an individual license that are working in those institutions. So I work predominantly with institutions, and I work also with collaboratives that are looking to network providers, payers, and other support social service agencies that are trying to coordinate care, help patients move through the continuum of care, make sure that there is care coordination. So there is a big spot for behavioral health and addiction services in that continuum of care. In fact, this is probably a population that needs continuity of care and care coordination more than any. Before I went to law school, I happened to be a social worker, a clinical social worker. So I worked in the behavioral health arena for almost 5-7 years. So I know the need of bouncing in and out of inpatient, outpatient, and that huge void. So health information exchange, which is what I kind of specialize in, really has a need for those, providers to come in, get networked in, go to your state hubs, go to your state agencies, and get yourself positioned to help out with those resources for that continuum of care, and getting patients through that continuum and all the things that they need when they're not inpatient. So
yeah, health information exchanges, what an awesome way to coordinate care, rather than having to tell your story over and over again, and people being able to make good decisions and be on top of what's happening with your healthcare overall. The health information exchange, they have it right there available. But with behavioral health and substance abuse or substance addiction, the privacy concerns and consent is very confusing and difficult. And how do organizations share that patient data with one another in a way that is legal, allowing for that really good care coordination? So that's what you help organizations navigate. Is that right?
Right.
Yeah.
That's right.
Okay. Yeah. In New Jersey and Arizona. Excellent. Well, this has been very, very helpful. So if you want to see more what Helen Oscislawski provides, please visit her blog page also. It's legalhie.com. And again, we'll put the links in the comment. So yeah, thank you very much. I really appreciate it.
Thank you, Ray. Thanks a lot. It's been fun.
You're welcome.
All right, take care.